Overreaching involves an abuse of a person's status as an advocate by taking advantage for personal gain of a person paying for an advocate to take advantage of that situation by making a fee, knowing that it is not a proper fee, but one that is unreasonable and improper, marked under the rules, is an abuse of the advocate's position and amounts to overreaching. The respondent went even further by taking money from vulnerable, desperate clients given their situations. He took an advantage of their situation by exerting position of power, in that he actually demanded that they pay him upfront, knowingly that he will never render the service as expected. The nature of complaints is similar in that all complainants paid money to his account or into somebody else's account at the instruction of the respondent. When inquiries or follow-up are done by the complainants, he does not respond. He simply threatens them. That's an abuse of and exploitation of its burst. The respondent contravened the provision of paragraph 3.6 of the Legal Practice Council's Code of Conduct, and that he failed to maintain legal professional privilege and confidentiality of the affairs of his clients. The applicant also pointed out that the respondent's conduct was serious by virtue of the Legal Practice Act. His conduct is considered to be serious, transgression and offences punishable. As this court, we have noted that from his answering papers, the respondent does not prefer an explanation for his conduct in accepting briefs and taking money directly from clients. He further does not deny that he misappropriated clients' monies. It was also not disputed that all the said complaints paid the respondent. It is also noted that the respondent had actually failed to cooperate with the applicant when he was called to respond to allegations leveled against him. More specifically, he failed to submit the relevant documentation despite repeating requests from the applicant. It is a fundamental duty of every legal practitioner to ensure that he or she is accountable on clients' funds. He is still expected to keep proper records, keeping of proper accounting records. It is not only for a legal practitioner who holds a Fidelity Fund certificate. Such is expected from all legal practitioners. This accounting recording underpins the rationale that the interest of the public must be protected at all times. Any failure to do so would be considered to be serious. It is paramount for a legal practitioner to ensure that the account is managed properly. The very essence of taking clients' monies should be risk mitigated. As alluded above, the issue of determination is whether the misconduct in question is so serious and of a nature that it manifests the lack of integrity, dishonesty, rendering him unfit to be a legal practitioner. In the belated affidavit of the respondent denies every allegation without any substantial evidence or effect. However, even when he made submissions from the bar, which is unorthodox in these proceedings, no evidence was presented to illustrate same. The fact remains he took money directly from the clients. Such monies were paid to him directly, others paid to other people's account. This court can safely conclude that this was misappropriation of funds, bearing in mind that no services was delivered or rendered by the respondent as expected. In our view, the misappropriation of clients' funds constitute theft, and the respondent further concealed this misconduct by manipulating clients in that he will assist them. This in itself portrayed dishonesty and lack of integrity on his part. This court is convinced that the applicant have laid sufficient grounds in striking off of the practitioner. Then this brings us to what the appropriate sanction would be. It was submitted that this misconduct warrants his removal. It was preferred as well by the applicant that this court could only order the suspension in exceptional circumstances. In these circumstances, it was argued that no such exceptional circumstances exist. A legal practitioner in duty is duty-bound to act in the interest of his or her clients above his or her own, in so doing exercise the highest degree of good faith in his or her dealings with his clients. It is tried that in applications of this nature, there is no list between the applicant and the respondent. The applicant, by virtue of his statutory duties, furnishes the court with the relevant facts and finding. Eventually, the court has to exercise its own discretion after having heard both parties. In the exercise of our discretion as this court, having considered the facts in their totality and having heard submissions on both parties, we find that the respondent's acts of misconduct were serious and dishonest. We are mindful that the main consideration is the protection of the public. It was not disputed that the respondent manipulated and forced the clients to pay money in his account or accounts of other people to such an extent of threatening them. One could easily make reference to Kambule's case and his colleagues going to an extent of breaching confidentiality. The respondent's misconduct was repetitive and he failed to provide plausible explanation for his actions. As alluded above, he filed a brief answering affidavit with bad denial. He failed to adequately address the various findings against him. This court was therefore limited to make a finding on the papers before it. Such calls for removal. His conduct warrants a finding that the respondent stands to be struck from the roll. The other part which I think is crucial, it's an issue of the respondent being the officer of the court having to mislead the court. Legal practitioners in nature, whether practicing as advocates or attorneys, are officers of the High Court. They are admitted by the court, which authorizes their enrollment in the practice in which they are qualified, and they owe a special ethical duty to the courts. The High Court retains an oversight over their conduct and the jurisdiction to pronounce on matters concerning their conduct. To this extent, they practice under the auspices of the High Court. The respondent's advocate, Teffo Malesela, was admitted as indicated as an advocate in the year 2009, that was in January the 5th. Given his years of experience, he is required to be a completely honest, reliable, and perform with integrity. The need for absolute honesty and integrity applies both in relation to the duties owed to their clients as well as to the courts. The profession has strict ethical rules to prevent malfeasance. This is for a good reason. As officers of the courts, advocates serve a necessary role in a proper administration of justice, given a unique position that they occupy. The profession has strict ethical rules. But then the respondent placed the matter on an unopposed role to secure a default, knowingly that it shouldn't have been there, it shouldn't have been. That on its own, one misleads the courts. Without regurgitating what I've earlier said pertaining the decisions or the orders that were granted by Judge Musa and Judge Fisher, I wouldn't go deeper into that. It went further to an extent that the Deputy Judge President, Ronald Sutherland, having to complain on behalf of the brother, being Judge Msimiki, and provided a report on the respondent's conduct as well as the court record in respect of his conduct in court, having to name unwanted names to the court. That on its own, it doesn't suggest a very good decorum and integrity of a counsel in court. In conclusion, it is reported to note that it is important to know that the respondent, as a legal practitioner, should have concentrated in fulfilling a dual function by assisting the clients on the one hand and by promoting justice in society on the other hand. The respondent had no absolute regard for justice. There is a case cited, which is Kek Cohen in J Law Society, where it was stated, a legal practitioner is a person from whom the highest standards are expected by the profession and the courts. The profession itself is not a mere calling or occupation by which a person earns his living. A legal practitioner is a member of a learned, respected, and honorable profession, and by entering it, he pledges himself with total and unquestionable integrity to society at large, to the courts, and to the profession. only the very highest standard of conduct and repute and good faith are consistent with membership of the profession, which can indeed only function effectively if it inspires the unconditional confidence and trust of the public. The image and standing of the profession are judged by the conduct and reputation of all the members, and to maintain this confidence and trust, all members of the profession must exhibit qualities set out above at all times. Therefore, this court is convinced Therefore, this court is convinced that the respondent's conduct no longer meets the requisite threshold of a fit and a proper person. This court is satisfied that the applicant has proven its case on balance of probabilities, that the respondent is not a fit and a proper person, and that his countenance in practicing would involve danger to the public or the good name of the profession. The respondent had actually contravened, like I indicated, Section 37, subsection 2A of the LPA, and in that the respondent failed to cooperate with the LPC investigation. This court finds that the respondent misled the courts in a number of occasions. He was even contemptuous in a number of instances. The respondent breached the court order of Judge Fisher by threatening Colonel Smith and subsequently was arrested and released on bail. The respondent consulted with clients without acceptance of a brief from an attorney. Instead, he accepted the brief directly from clients, thus contravening Section 34, subsection 2A, I, and paragraph 27.2 of the LPC Code of Conduct. The respondent accepted payments directly from the clients without receipt or a brief from an attorney, thus contravening paragraph 27.4 of the LPC Code of Conduct. The respondent utilized attorney's details without their consent. The respondent assaulted and intimidated members of SABC, which resulted in an agent interdict application prohibiting the respondent from entering the premises of SABC and the state attorney. The respondent is being investigated for corruption activities as defined by POCA. The applicant presented a letter, a scornful letter written by the respondent. It's a letter written by the respondent, which is dated the 25th of July 2022. The letter was addressed to one advocate, G.D. Baloyi. It was written by Advocate Teffo, the Director of Public Prosecution, Gauteng Division in Pretoria. What he alleged in his letter, he said this court is not certain. Well, this court is not certain as to what to make of this letter, as it's not a complaint against the applicant. It is directed to Advocate Baloyi. In silent, the respondent asserts in this letter that he has been experiencing harassment by the courts, the state, i.e. the police, the Minister of Police, the prosecution, including the Office of the Director of Public Prosecution in Johannesburg, further making reference to the court of Judge Maumela in the presiding matter, the presiding officer in the case that is currently going on. This court does not have a jurisdiction to deal with the current occurrences of another court. Therefore, this court will not concentrate much on untested and unfounded allegation raised by the respondent. This court will not waste time in dealing with delinquent assumptions and misconstrued aspersions leveled against officers of the court. Needless to say, the court is short of words in attributing this level of behavior projected by the respondent. Safe to say that he has no regard for justice. Respondent going to such an extent of blaming the office of the president for his arrest on the 28th of April 2022 in court. There is no basis of these allegations. Entertaining this allegation will not take this matter anywhere. It is said that an advocate must serve many masters. The respondent has not attempted to deal with any of the complaints leveled against him, including other complaints stated in other annexures which the court did not deal with them. It is our view then that the contention by the respondent that the applicant failed to give him opportunity to address the complaints with him personally by way of an inquiry before the applicant should not be given as an excuse for not dealing with them, because in these proceedings the respondent is given yet another opportunity to address the said complaint. This is so because the court is not only confined to pronouncing on the transgressions of the Act, the rules and the code of the conduct. The court, depending on the gravity of the offences, is also required to exercise a discretion whether to suspend or to strike the respondent from the role of legal practitioners. What the court is faced with are bare denials, where the respondent has not defended with any particularity the complaints against him. We do find then that the respondent lacks the sense of responsibility, honesty, integrity, and such attributes are characteristics of an advocate. It is clear that the respondent does not possess any of the above. This court is satisfied that all various aberrations have been established on the preponderance of balance probabilities, bearing in mind that this court has taken into cognizance that the purpose of these proceedings to strike an advocate from the role is the protection of the rules regulating the profession rather than punishment of the transgressor. In the circumstances, the removal of his name from the role of legal practitioners is justified. We are mindful that the applicant is entitled to cost. An order has been sought that the respondent to pay the cost of this application on a scale is between attorney and client. We have considered the submissions and find that in these circumstances punitive costs are justified. Or are not justified. I beg your pardon. Punitive costs are not justified. It is tried that in application of this nature, there is no lease between applicant and the respondent. The applicant is performing its statutory functions of placing facts before the court to exercise its disciplinary powers over trained practitioners. The applicant is entitled to cost. The following order is made. 1. The respondent, Advocate Malesela Teffo, is hereby removed from the role of legal practitioners. 2. The respondent must surrender and deliver his certificate of enrollment as a legal practitioner to the registrar of this honorable court. 3. In the event of the respondent failing to comply with the terms of this order detailed in paragraph 2, within 2 weeks from the date of this order, the sheriff of the district in which the certificate is be authorized and directed to take possession of the certificate to hand it to the register of the honorable court. The respondent is prohibited from handling or operating on his banking accounts used in receiving monies for the client. 5. Johan van Staden, the director of the Gauteng Provincial Office of the applicant or his successor as such, in his capacity as such, be appointed as a curator bonus to administer and control the banking accounts of the respondent, including accounts relating to insolvent and deceased estate and any estate under curatorship connected to the respondent's practice as a legal practitioner, and including, if applicable, also separate banking accounts opened and kept by the respondent at the Bank of the Republic of South Africa. Thank you. Yes, I've read the orders up to order number 5. Order is fairly extensive. I think it goes up until number 13. The rest of the order is stipulated in the founding papers and notice of motion of the applicant, and such is made an order of court.
that is as is reflected in the draft order submitted by the applicant, which is confirmed and made an order of this court. I agree with the judgment. It is so ordered. At this stage, we hand down the judgment and court is adjourned.
Yeah.